of your emotions can make the confidence ring. Yet in all your might and glory, vanished from the skies, leaving just another story, mysteries of man-made lies. They tell of how you fell from the sky.
All right, welcome to another edition of the Free American Hour. I'm your host, Clay Douglas. Louis Ewing is my guest. Hello, Louis. Can you hear me all right, and are you there?
Yes, I'm there, and I hear you fine.
All right. We just went through the 4th of July. My guest yesterday was a grower in California, growing cannabis, and I kind of wanted to focus on that. You know, we just got medical marijuana in Arizona, and we've got medical marijuana there in California. I think that's a great start. I wrote a book 40 years ago about a country, the United States, where there were no laws against victimless crimes. All laws against victimless crimes have been abolished. And to me, that 40 years ago, that seemed like an ideal state of affairs. But I was a little bit intimidated because I was sitting in a prison in Texas when having a joint was a felony punishable by 99 years or in prison. I didn't think that was right at the time. I don't think it's right now. I think we've got way too many people, more than any country in the world, in jail on some kind of crime. And if I'm not mistaken, you don't think smoking a joint or having a little pot in your pocket is a crime at all? Is that am I accurate about that?
I know for a fact that marijuana is not illegal, never has been, and never will be. The law enforcement, specifically the prosecutors, are intentionally mistraining the police officers. And I'm going to have to lay out a little bit of the history. Do you remember when alcohol was illegal?
I remember. I certainly have studied the fact that they made our grandfathers, our great uncles, into criminals by calling them bootleggers and moonshiners, and all they were doing is what they've been doing for years and years and years, and that was making fuel for their vehicles.
Right. Alcohol was illegal because of prohibition. So we had moonshiners, bootleggers, we had Al Capone. And basically, okay, back then, the Constitution said the sale of alcohol was prohibited. And so everybody did it on the down low. And so people had to smuggle alcohol. They were called bootleggers and moonshiners, you know, and everybody wanted to get drunk and have sex on the weekend. Girls wanted to say, I wouldn't have did that if I wasn't drunk. You know, and everybody wanted to party. So eventually, you know, the police powers, they kept harassing, you know, the general public until the general public was dumb enough to vote to give our government the authority to regulate and tax it. So they had a constitutional convention to amend the Constitution to make the sale of alcohol now legal. That's why we have state-regulated liquor stores. That's why when you walk into Safeway, Albertsons, or QFC, into the walk-in cooler, you'll see a big square plaque on the wall somewhere posted very conspicuously that says State of Washington Liquor License, or State of California or Texas Liquor License, or wherever you're at, you'll see the liquor license posted on the wall. Now, where in the Constitution does it say that the sale of marijuana is prohibited? It doesn't. So guess what? We don't need to have a constitutional convention to amend the Constitution to make the sale of marijuana legal, because it's not illegal to start with.
Now,
so everybody's saying, well, how can people go to jail for it? Well, let's take a look. Here in Washington, I'll give you the example. All drug offenses are not in Title 9, 9A, or 10, the General Criminal Codes. They're in Title 69 the pharmaceutical code. The same applies in every single state. All the marijuana and every other kind of drug, cocaine, mushrooms, peyote, ecstasy, you know, everything is in the pharmaceutical code. And I found 2 statutes on the law books, and I give out a free flyer laying these 2 statutes out. These 2 statutes, one of them is called the registration statute, and the other one is the definition statute. And these 2 statutes have never been argued by any attorney in any of the 50 states as an affirmative defense that would allow you to lawfully possess drugs. And here's how I can prove that it's not illegal even in the current code today. In every single state, when you read the statutes carefully regarding manufacturing or possession, or either one, both, it says it shall be unlawful except as otherwise authorized by this chapter. It shall be unlawful to manufacture whatever, except and that's for the manufacturing statute, whatever kind of drug you're manufacturing. Now for the possession statute, same thing. Except as otherwise authorized by this chapter, it shall be, you know, unlawful to possess drugs. But both manufacturing and possession says with intent to distribute. It shall be, except as otherwise authorized by this chapter, it shall be unlawful to manufacture with intent to distribute any kind of drug, whatever the drug it is. Same thing with possession. Except as otherwise authorized by this chapter, you know, it shall be unlawful to possess, you know, drugs, whatever, with intent to distribute. Now, how do I know what your state of mind is any more than I know what your state of indigestion is? They put a rebuttable presumption in the statute, or basically what's kind of technically illegal, unconstitutional, because the burden of proof is always supposed to remain on the prosecutor. But what they do is they go ahead and charge you with the charge and then leave it to you, a person who's not an attorney, not a member of the bar, no training in law, to try to defend yourself in their courtroom. And not knowing court rules, statutes, and case law, and rules of evidence and rule of procedure, your option is hire an attorney, accept a public defender, or try to do it yourself if you're capable, which most people are not. Therefore, they're getting away with mistraining people, mistraining the cops, and brainwashing the public into believing public policy, drugs are illegal. And that's why there's so many people in jail, because they are misapplying the law, you know, with statutes that don't apply to you, unless you're a licensed pharmacist or a licensed medical practitioner who's prescribing the drug for some kind of a medical condition. And so that's fine and good for the people who actually do have a medical condition. They can apply for medical, but I think down the road they're probably going to try to repeal, you know, completely get rid of those medical marijuana statutes. Because remember one thing, a statute is just a civil right protected by a statute. What the government can give you, they can take away. But one thing they can never take away from me is a civil liberty. Okay? I'm exercising a natural right that they don't have authority to regulate or tax. This is why the government is harassing people with drugs, because they're hoping that people are stupid enough to vote to legalize, to make them their one and only drug dealer. If you really search and find out carefully, you'll find out it's the government that's sponsoring all these hemp fests. They're the ones that are putting the money behind all these big hemp fests, because they want the people to vote to legalize it so that you can make the government our one and only drug dealer. They want to have an exclusive monopoly.
Bush, wait a minute, wait, they already are. The CIA, the Mossad, the intelligence services that are working for the banksters, that are working for the one world government, they're behind all of the drug cartels. They brought it in with George Bush as CIA director. They brought it in.
Yeah. What did Clinton say? I smoked marijuana, but I never inhaled.
Yeah. Yeah. I got a bridge here in Arizona that I'll be glad to show you.
That got to be the funniest thing I've ever heard a president say. I smoked, but I never inhaled. Now, what about Bush? Didn't he actually admit to it?
Well, Bush, you know, they didn't call him Poppy Bush for nothing, you know. I mean, remember him throwing up on the Japanese Prime Minister? Why do you think he did that?
What, so Bush was a heroin user?
Yeah.
I didn't know that one.
Clinton was the cocaine. All the cocaine was coming in. Of course, so was Bush and Jeb. Terry Reid delivered a kilo of cocaine to him with Barry Seal. That's the pilot that they murdered down there in Baton Rouge.
Wow.
Who I happen to know both of them, Terry Reid, and I met Barry Seal in Dallas.
Well, I'm gonna read you this Washington statute. It's RCW 69.50.302 subsection 3C3 registration requirements. Now keep in mind, only a licensed medical practitioner or a licensed pharmacist is required to register. Okay, subsection C says the following persons need not register and may lawfully possess controlled substances under this chapter. Subsection 3 says an ultimate user or a person in possession of any controlled substance pursuant to a lawful order of a practitioner or in lawful possession of a substance included in Schedule 5. Now, I've had people show this to attorneys and public defenders and prosecutors and judges, and in every single case, the attorney, prosecutor, judge, all being members of the same state bar association, all lied to the various people that I'd sent to ask them this question, and they said, "Oh, no, you have to be an ultimate user. You have to have a prescription to be an ultimate user." Well, you look at the statute carefully, it doesn't say that.
That's always really bothered me. I went to a doctor here. Oh yeah, we don't give scripts out for that. We don't do that here. You can't get that here. And they in the conversation they said something about, well, the pharmaceutical companies are just synthesize it and put it in a pill so you can just sell it right over the counter at a drugstore. I said, oh, in other words, you want me to come and pay you for a visit so you can write a prescription that the local Walgreens is going to make money off of and the pharmaceutical company is going to make money off of, all for a plant I could grow in my backyard? It doesn't make sense. That doesn't make sense to me.
Well, yeah, it does.
This is all a pharmaceutical. I mean, a pharmaceutical, if you're buying a Valium, you're paying 2,000 to 10,000% markup on the ingredients in that pill.
Well,
so what you're explaining to me, what I'm getting from what you're saying here is this is nothing but an illegal racket set up, foisted on the American people to make us into criminals, to put us into the gulags. And we don't even know, there's no reason why for them to do that.
It's just another tithe or gift of the Goyim. Okay? Now, back to that statute, when you look at it carefully, it clearly refers to two classes of people because it uses the word persons. It doesn't use the singular word person. It has an S and an, persons. Following persons need not register and may lawfully possess. You got an echo on your phone.
Okay, well, that may be.
Okay. It says an ultimate user or, subsection 3 is worded in the disjunctive. It says an ultimate user or a person in possession of any controlled substance pursuant to a lawful order of a practitioner or in lawful possession of a substance included in Schedule 5. And I have case law that says when they put the word or in a statute, it's presumed to be used in the disjunctive sense. And the case law says when they put the word or in a statute, it presupposes there's a choice of one or the other, but not both. So now the question becomes, well, what's an ultimate user? Well, the attorneys who compose 100% of the Code Revisor's Office in Washington, they decided to hide it a few statutes away. The definition of ultimate user is contained at 69.50.101 subsection BB. And ultimate user is placed in quotation marks, and it says ultimate user means an individual who lawfully possesses a controlled substance for the individual's own use, or for the use of a member of the individual's household, or for administering to an animal owned by the individual, or by a member of the individual's household. And me being the smarty pants that I am, I wrote on my flyer, Washington law allows me to get my dogs and cats high if I want to.
Now, but are you saying, Louis, that we're being tricked again into going out and trying to we got medical marijuana, so a few people that don't mind paying the pharmaceutical racket can smoke a little bit of pot that they buy from another state authorized dealer, and so the state's in there with their hand out.
Well, you know,
but we shouldn't be working. We shouldn't be working for legalization. Or you know, there should be no laws. In my opinion, there should be no laws against victimless crimes.
There isn't any law against the possession of marijuana or any other drug with the intent to smoke it or use it yourself. There's only two statutes on the books, basically. One is manufacturing with intent to distribute, and the second one is possession with intent to distribute. And that charge, possession with intent to distribute, is a lesser but included offense of manufacturing with intent to distribute. And in every single instance, people need to look to their state constitution, to the nature and clause provision, which is also called the case law. The annotated case law for your constitution annotated would be called the essential elements cases. And the leading case in Washington, I don't have the site right now, but it's called State versus Holt. It says the omission of any statutory element from a charging instrument constitutes a fatal defect to the charging instrument that could be raised for the first time on appeal, even after conviction, even though you never raised it at the trial level. Okay, so they have to prove every element of a charge. And the leading federal case that proves what I'm saying, that the possession with intent to distribute or manufacturing with intent to distribute, is a case called United States versus Jewell, which is 532 Federal 2nd, page 697. It's a Ninth Circuit case, February 27, 1976, and it cites a case called United States versus Clark, 475 Federal 2nd, page 240, Second Circuit, 1973. It says, quote, "The statute is violated only if possession is accompanied both by knowledge of the nature of the act and also by the intent to manufacture, comma, distribute, comma, or dispense." So there you go. The possession or manufacturing, in order to prove either charge, they have to prove that you intended to distribute. So at trial, they have to establish testimony or evidence that you either distributed or attempted to distribute, or that you actually dispensed or attempted to dispense. If the only testimony they can get from the officer is, well, officer, how did you find the drugs? Well, I found it in the car. Was there anybody else in the car? Well, no. Did you see me attempt to sell or give away this drug to anybody else? No. Officer, did I attempt to sell you the drug, or did I attempt to give it to you? Well, no. Well, officer, didn't I tell you that this was my own stuff and I bought it for myself with intent to smoke it myself? Well, yeah. And you found a scale on me, didn't you? Yeah. Didn't I tell you the reason that I own a scale is because I'm tired of being ripped off by drug dealers and I wanted to make sure I'm getting what I pay for? Well, yeah. Is it illegal to own a scale, officer? I mean, I bought mine at Bon Macy's, you know, Frederick Nelson or JCPenney or Sears, you know, and I use a scale all the time. Is owning a scale illegal? Why don't you go close down all those stores for selling illegal scales? I didn't know scales were illegal. You see how where we're going with that?
Yes, sir. Now,
so tell me, how do you think now drugs are illegal? Can you counter what I said? I mean, doesn't what I say make sense?
Yes, it does.
I had a 15-year-old boy 8 years ago beat a judge and a cop following my instructions. His mother hired me to do their paperwork for him. and following my written instructions, was able to beat a possession of paraphernalia charge in the city of, guess what? Grass Valley. And it pissed off the judge everywhere. I put the city of Grass Valley, I capitalized, bolded, underlined, and quotated marked the city of Grass Valley to make it stick out on the legal pleading. And I had the 15-year-old kid put the cop up on the stand and asked the officer, you know, how many years he'd been a police officer, and he'd been a police officer 30-something years. And I had the kid ask the cop, have you ever charged people with possession before? He said several thousand times. He asked the cop, well, you don't go around charging people with violations of statute that you've never read. The cop got offended, scolded the kid, you know, who is he to question him, blah, blah, blah. And, you know, he'd already stated that he'd given out thousands of these tickets, and no, he doesn't go around charging people with violations of statutes that he'd never read. That was absolutely ridiculous, you know, from some snot-nosed kid with disrespect to a police officer, highly decorated, blah, 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 like him. So I had a kid, you know, following instructions. I know in advance what the cops are going to say and what they're going to lie about. And the kid goes, well, Your Honor, may I approach the police officer? And the judge says yes, asking him what the purpose was, and he said he wanted to hand him a copy of an exhibit. And the judge approved that. He goes up, the kid goes up and hands the cop a copy of the statute, and for the California Code, which reads the same way as the Washington Code. I don't have the California Code in front of me right now, but I'll read you the Washington Code. And he asked the officer to read the first sentence in the Paraphernalia Code after asking him a few cute questions. Officer, did you see me using the pipe? And the officer says no. And, well, officer, is there any requirement in the Paraphernalia statute that you have to see me actually using the pipe in order for you to charge me with it? And the officer said no. And officer, for the record, where did you find my pot pipe? And the officer says, well, I found it in your back pocket. Now the kid asks silly questions because I'm a smart ass. Well, officer, did you see me smoking the marijuana out my rear end? Was I smoking it out my butt? I had the kid actually say this to the cop, just messing with the cop really big time. And so we have the officer read the statute, and the officer said, no, there's no requirement that you have to actually be using the pipe. And he's charged several thousand people. We had him ask him that again for the record. And if no, it's absolutely ridiculous to accuse me of charging people with statutes that I don't read. That's preposterous. Here's what the statute says. It is unlawful for any person to use drug paraphernalia to plant, propagate, cultivate, grow, harvest, manufacture, compound, convert, produce, process, prepare, test, analyze, pack, repack, store, contain, conceal, inject, ingest, inhale, or otherwise introduce into the human body a controlled substance. Any person who violates this subsection is guilty of a misdemeanor. That's the first prong. The second prong is, it is unlawful for any person to deliver, possess with intent to deliver, or manufacture with intent to deliver drug paraphernalia, knowing or under circumstances where one reasonably should know that it will be used to plant, propagate, cultivate, grow, harvest, manufacture, compound, convert, produce, process, prepare, test, analyze, pack, repack, store, contain, conceal, inject, ingest, inhale, or otherwise introduce into the human body a controlled substance. Now, officer, did you just commit perjury? Did you just state for the record a few minutes ago, like 3 or 4 times, that you don't go around charging people with violations of statute you've never read? Now, I want you to answer this question for the record. Since we just had you read that statute for the record the very first time in your career as a police officer, can you again state for the record that you've read this statute before? And the officer's choking on the stand. The judge slams his gavel, dismisses the case, gives the lady a lecture for encouraging her son to smoke marijuana, and the lady told the judge, well, we smoke together, he's my son.
This is in California. Now, how does this go across the country? I have not been keeping up on the laws around the country.
Well, I'm working on creating flyers. Hopefully, I'm going to have all 50 states done by the time the Hemp Fest rolls around. So I got to hurry up and get to work on it. I may have trouble with California though, because I did so far. I found one of the two statutes. I found the statute defining ultimate user means the individual uses it for their own purpose, but I have not found the registration statute. The California code, on the flip side, I say 50-50, I say California code is 10 times easier than any other state statutes because they write very lengthy explanations about the law and what the law is. It's very clear. However, California code is also twice as hard as any other state to find the law because there's so many gosh darn law books. If you go to a law library and you look how large their statute, their volume of books, there's so many volumes of books. They have 5 to 6 more times laws on the books than any other state. In Washington, we got, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9. We have 9 reams of books. 9 reams. That's the total law for the state of Washington. But you go to a law library and you look at the bookshelves, you'll see about 50 reams of law books. And they've spread out their code into many different code sections and statutes, so I just haven't quite found the other half of the statute. The other states are going to be real easy. I have ultimate user flyers for Oregon, Idaho, Utah, Colorado, Nevada, North Carolina, South Carolina, Illinois, and Iowa, and Georgia, and Texas. And I'm working on putting out an ultimate user flyer for every other state. They're free. You can send me an email to anybody who's listening to RCW, that stands for Revised Code of Washington, RCW Codebuster at gmail.com or rcwcodebuster at yahoo.com or AOL.com, and I will send these free flyers out to anybody that asks for them. And I'm telling you that since the last 6-7 years, since I handed out 10,000 copies at the Seattle Hemp Fest, not one person in this state has ever been busted for possession of marijuana in any quantity, including my ex-girlfriend with half a pound of weed in the car. Okay? And that's when she's driving while suspended with a failure to appear arrest warrant in the Burien District Court. The cops basically told her they didn't want anything to do with Louis Ewing's girlfriend, and the cops admitted to her that they like what I'm doing, good things for the people, whatnot. And the cops actually, this was funny, they went back to their car and they got my flyers. They carried it to the window. My girlfriend's like scared. And the cops, the Pierce County Sheriff is showing the flyers. Is this your boyfriend's flyer? This is your boyfriend's flyer right here. And my girlfriend freaked out. She goes, why do you have his flyers? And the Pierce County Sheriff told my girlfriend, my ex-girlfriend, that, well, once in a while we have, one of our wife's friends or somebody who's a friend of a friend will get busted for possession. And we'll hand them one of these flyers, and we'll call the prosecutor and say, hey, this person here has one of Louis Ewing's flyers, and the prosecutor will tell us to let our wife's friends go. Hint, hint, hint. In other words, there's a lot of cops' wives that smoke marijuana. In fact, I personally know